the historical background of the framing of Article 324. Article 324 and the enactment of the new act has been already dealt with in great length. I shall confine myself to the validity of the impugned provisions and the appointments made thereunder, Lordship. That the impugned provisions are ultra vires, Article 14 and 324, as interpreted by the Constitution Bench in the case of Anup Barnwal. And they failed to, Lordship. The important point is that they failed to take care of the serious lacuna which was fully accepted and shared by Dr. Ambedkar in his reply to debate on Article 324, Lordship, which I have reproduced in para 17, Lordship, of my writ petition at page 11. Kindly permit me to read just one sentence, opening sentence of that para 17 at page 11, Lordship. That replying to the debate of Dr. Ambedkar had said, and I quote, "There is a great deal of force in what my friend Professor Saxena said, that there is no use making the tenure of the election commissioner a fixed and secure tenure if there is no provision in the Constitution to prevent a person who is likely to be under the thumb of the executive, Lordship." This serious lacuna was accepted by Dr. Ambedkar, but the new act also, it fails to take care of this lacuna, Lordship, apart from violation of Article 14, Lordship, which I shall come to later, Lordship. Then, Lordship, consequently, the impugned provisions
Please continue, sir.
Dear Lordship. Consequently, these impugned provisions, they give a free hand to the executive of the day to misuse the power of office, as has been, they have misused the power given by the act to them. Confirming the observations in para 204 of the lead judgment in the case of NJAC, NJAC case, wherein it was said that, and kindly permit me to just read two sentences from that para 204 of the lead judgment in the NJAC case, Lordship, wherein it was said, what emerges, I'm quoting from para 2, just two sentences to save the time of the Honorable Court. What emerges is trappings of the spoil system and nothing else. This is what the court had observed then, Lordship, which is happening, coming to be true even every successive day. Lordship, that was the first sentence. The other sentence in this very para, the Lordship observed was, demonstratively, that is exactly what has happened repeatedly in the matter of non-judicial appointments like this, like the present one. So what the Honorable Court had observed in the case of NJC is being repeated in this case also, it has been repeated, Lordship. Then, Lordship, now, yes, Lordship. Now I'll come to the impugned provisions, Lordship, as to why they are untenable. Lordship has brought out in paras 45 and 46 of my writ petition as page 27 and 28. 27 and 28. Approval of the cabinet and the Parliament on the 23 bill was obtained by concealing the relevant material like the report of the National Commission to review the working of the Constitution and the report of the Law Commission. Those were not brought to the notice of the Cabinet and while approving the Cabinet note while approving the bill for presentation in the Parliament, nor were they brought to the notice of the Parliament. And their approval was obtained by concealing these reports, and it was given without application to these reports, Lordship. That is my point, and
Sir, where is the
that's
cabinet?
why that approval was vitiated, Lordship, both of the Cabinet as well as the Parliament.
Is the cabinet note on record?
Yes, Lordship.
Is the
Yes.
cabinet note on record?
Yes, Lordship. I have filed a copy of that. Yes, Lordship. I have annexed it with my petition. I obtained it
Where is
under
it
the
in your
RTI Act,
petition?
Lordship.
Which page?
The Cabinet note which was put up to the Cabinet.
Where is it in your petition?
Lordship, 1 minute. It is in the petition, Lordship. It is there. It has been filed in the petition. Lordship, 1 minute. Note for the Cabinet, that is at page 96, Lordship. I obtained it under the RTI Act, Lordship. From page 96 onwards, it is the Cabinet note. It is totally silent about these two reports, Lordship.
Page 88 it starts. The cabinet.
Dikhai?
Yes, Lordship. So that was my first point, that the approval on the bill was obtained by concealing these reports from the Cabinet as well as from the Parliament. Then second point, Lordship, is, if I can, yes. The second point is that the statement of objects and reasons, Lordship,
Give it,
which
madam.
is at page 104 of my statement of objects and reasons of the bill for this 2023 Act, that is on page 104 of my writ petition, Lordship. Annexure, it is Annexure P8 at 104.
Yes.
Yes. Lordship will be surprised to see that this SOR did not even mention the grave legitimate concern of the framers of the Constitution about the imperative of the apex court to intervene, leave alone indicate as to how the bill took care of it, Lordship. They didn't bother to address this issue in their statement of objects and reasons for coming up with this bill, nor it gave any explanation for changing the selection committee named in the Constitution bench judgment, which was as per recommendation of the Law Commission, Lordship, which was concealed from the Cabinet and the Parliament. They didn't give any reason for not, they didn't consider even the recommendation of the Law Commission, which was as per the judgment in the Hon'ble's case, Lordship. So that is significant. This is the second reason as to why the approval of the Parliament was vitiated, Lordship, on the Act. Then,
It's also there in the SOR.
It is there.
yes, Lord. Lordship, then the impugned provisions in section 7 and 8 of the Act, which are reproduced at page 23 and 24 of my writ petition, and they are also in Appendix B to the writ petition.
Yeah, yeah. Cabinet.
Yes, sir.
Yes, Lordship. These section 6 and 7, Lordship, they do not meet the requirement of the selection process,
So you.
ensuring the four fundamentals of the election commission: impartiality, fearlessness, transparency, and purity, stipulated by the constitution makers while enacting Article 324, Lordship, and mandated in the judgment of the Constitution Bench, on which, Lordship, this is important, the Minister for Law and Justice had also agreed in his reply to the debate on the bill. He agreed with these four requirements of the Election Commission, but he brought a bill and got it passed which don't meet these requirements, Lordship. This is the difference in what is said and what is done, Lordship. In view of the law laid down by the Constitution Bench in S. Krishnan versus the State of Madras, Lordship, AIR 1951, Supreme Court 301, AIR 1951, Supreme Court 301, and 1951 SCR 621, Lordship. The same citation, same case, different citation.
You are
That
relying on
any
which paragraph,
enactment
sir? Which
passed-
paragraph of this judgment?
Sorry,
Which paragraph of this judgment you are relying on?
I've got the page number at 624. This is said. What I'm quoting, the judgment is reported at 621, but the sentence I'm going to quote is at 624, Lordship. The
This is from the
their
SCR?
observation, the Lordship's observation, that any
Yeah, yeah.
नहीं, AIR
Yeah.
बोला 301.
yes, sir, 1950 yes, Lordship, 1951 SCR 621. Sorry, page 634.
SCR.
Judgment is at 621, and the sentence I'm quoting is at 634, wherein it was held that any enactment passed with the purpose of defeating constitutional provisions, like in this case Article 14 and 324, can be assailed on the ground of being a fraud on the Constitution. So this act also, Lordship, is nothing but a fraud on the Constitution, in which, in view of the reasons which I have mentioned and I am going to mention further. So
Laptop
this is the submission as regards section 6 and 7 for both. Now I'll deal with these sections separately, Lordship. That is the general point applicable to both the sections, Lordship. Then section 6 relating to search committee is liable to be struck down for the three reasons which I have mentioned at page 2 of my written submission. Lordship, I had filed my written submissions in this matter, which were circulated with the office report dated 5th of May, Lordship. That is important. These written submissions are already on record, Lordship. They were circulated with the office report dated 5th of May this year, Lordship. So I'm only referring to the submissions in those written submissions, based, of course, on the pleadings. So, Lordship, the search committee is liable to be struck down.
Yes.
Yes, Lordship. The first reason as to why Section 6 needs to be struck down is that the amendment to Clause 6, Lordship, to the bill was moved by the minister without the requisite approval of the cabinet under Rule 4.1 of the Government of India Transaction of Business Rules 1961 and was got passed by the Parliament, concealing this fact, hence cannot be sustained for this reason, Lordship. This amendment was not got approved by the cabinet because for the reasons which I have mentioned in para 49, Lordship, of my petition, at page 30, Lordship. It was moved without the requisite approval of the cabinet under Rule 4.1 of the Government of India Transaction of Business Rules, Lordship. And any decision taken in violation of the rules, of course, Lordship, cannot be sustained. Then secondly, the secondary, sorry. Lordship, this I have stated in para 52 of my petition. This reason is in para 52 of my writ petition at page 3132. Page 3132, para 52. This reason I have given in detail, Lordship.
Yes.
In the writ petition. Then, Lordship, the second reason is that significantly, even while moving the official amendment for replacing Clause 6 by the present Section 6, the Section 6 makes the minister chairman of the search committee, Lordship. In the original bill, it was the cabinet secretary, as usual. Cabinet secretary is generally the chairman of the search committees in all the search committees, Lordship, for various constitutional and administrative posts, high posts. It has been the cabinet secretary. Here, the original bill also, Lordship, provided for the cabinet secretary, but it was moved, and this amendment was moved at the time of the debate on the bill, Lordship, by the minister at the last minute. So even while moving this official amendment for replacing this Clause 6, which provided for cabinet secretary by the minister, no explanation was given to justify the change regarding the committee being headed by the minister instead of the cabinet secretary, and for dropping the words having experience and in matters relating to elections. So this change was made surreptitiously at the time of moving the bill. Nor were these changes discussed during the debate, Lordship. This is important because I have gone through the debate on the bill, and this change was not discussed at all, Lordship. I have mentioned all these things which I am submitting, Lordship, in my written submissions.
Yes, yes, yes. $51 is.
S. Krishnan, which paragraph are you relying on?
Lordship, for this, this is there in para 53, Lordship, of my writ petition.
No.
This is, I'm referring to that.
The particular passage from S. Krishnan
this,
you read out
but
is
yes, Lordship.
which paragraph? 51 Supreme Court. Which paragraph?
Yeah. 53, Lordship, at page 32. 53, para 53, page 32, Lordship. The submission is there, Lordship, from that.
No,
paragraph.
but how does the paragraph start? What is the starting words?
1 minute. 1 minute, Lordship. I'll just. Lordship, may kindly have my amended petition, because the original petition was subsequently amended twice, and this I'm referring to the amended petition, Lordship. Para I'm mentioning of the amended petition. 52, I'll just read, Lordship. It starts with this. 1 minute. Yes, Lordship. This is at page 31. That a perusal of the aforesaid note dated 6/12/23 in file number such and such, received with the letter dated such and such of the legislative department refers to the herein before, shows that the approval of the cabinet for the change in the composition of the such committee proposed in the original bill was introduced in August 23 was obtained without sorry. That was regarding the first point, Lordship.
Regarding the
Para
first point,
52.
sir, which paragraph of
At page
S.
31.
Krishnan are you relying on? Can you give us the paragraph number and the starting words?
Lordship, Lordship. For the first point, Lordship, para 52 of the amended writ petition, Lordship, at page 31, Lordship.
From the judgment in S. Krishnan, AIR 51, which paragraph of the judgment?
No, the AIR 51, because I don't have the para number of the AIR.
SCR does not have paragraph numbers. SCR does not have paragraph numbers, so please tell
exactly,
us,
Lordship.
how does the paragraph start?
Lordship is right. Lordship is right. For the SCR, I have given the page number. The judgment begins at page
Sir, please try to understand.
621.
Please read
The
out.
earlier judgment, Krishnan versus the State of Madras.
Can you read out the paragraph in its entirety from the first
Yes, sir.
word? You said that if any law is enacted to defeat
No,
the constitutional provisions, it would
Lord-
amount to a fraud.
Lo-
Where is this particular expression in the judgment? Which particular
sir.
paragraph?
Lordship, I don't have the para number, but it is at page 634 of the judgment in the SCR.
Sir, do you have a copy of judgment before you? Sir, do you have a copy of
34.
judgment before you?
No, Lordship, I don't have copy of the. I got this.
No.
I got this sentence while going through the judgment in the net. While going through the judgment in the net, I got this copy. I mean, this particular sentence, which I thought is applicable to our case. I am giving the page number of the SCR, Lordship, where this sentence is. There, 634, Lordship. The judgment is at page 621, and this observation is at page 634, Lordship. Page number I have got, not the paragraph number, because it is not there.
Let's say.
34.
Page 634, Lordship.
1 second.
It was held in that case, Lordship.
But sir, this is saying it was frankly conceded that if Parliament or a state legislature passed legislation in a manner which amounted to a fraud on the Constitution, inasmuch as those enactments were passed with the purpose of defeating the constitutional provisions, then those laws could be attacked on that ground, but not on the ground of their vires.
Yeah.
That in the present case, no such argument had been taken or could be taken. And that being so, the contention of Mr. Nambiar was not justified.
Can I give the para number?
There is no paragraph.
No, in SCC, it is reported, it starts in para 34, in SCC, my lord.
That will be an AI.
Already has it.
I'm saying,
Look, there are judgments given by 4 learned judges.
yes, my lord.
So
What
the
my-
lead judgment is by Justice Patanjali Shastri,
Please, your lord.
right? The portion on which Mr. Shukla is relying is by Justice Mahajan,
Yes. Concurring judgment.
concurring view.
And it starts with saying, after a careful consideration of the argument by Mr. Nambiar, I have reached to the conclusion. My lords have got it.
Yes.
If your lordship have SCC, my lord, I
And
can.
we are on that paragraph 34, SCC.
Please.
Yes. But is it law declared? That is what is to be found out. Very strong words, no doubt.
It can be asserted.
Whether it is law declared, that has to be shown. Very well. Continue, Mr. Shukla.
Lordship, it was said that it can be asserted. Yes, Lordship. Yes. Yes.
Yes,
Can I
yes, sir,
continue,
proceed.
Lordship?
Please proceed.
Sir, please
Yeah.
continue.
Grateful, Lordship. That was earlier, Lordship. Then I was on this section 6 being liable to be struck down. The first reason I had mentioned that it was moved by the minister without the requisite approval of the cabinet.
Right.
That is in
Yeah,
para
okay.
52 of my writ petition, Lordship. Then I was on the second point that the it didn't give any explanation for to justify the change in the committee had to be headed by the minister instead of the cabinet secretary as proposed in the original bill. Lordship, this point is in para 53 of my writ petition at page 32, Lordship. Evidently, the approval of the, on this point, I am quoting this, evidently the approval of the House on the said amendment was obtained and given without any application of mind, contrary to the law laid down in ONGC Limited versus Western Geco International Limited, 2014, 9 SCC 263, para 38. This I have mentioned in para 53 at page 32 of my writ petition. This is the second reason as to why section 6 cannot be sustained.
Yes.
Then, Lordship, the third reason is it is also violative of Article 14, being vague, irrational, and arbitrary for the reasons detailed in paras 54 and 55 of the writ petition. I'm summarizing: by making the minister chairman of the search committee, its political neutrality and fairness has been clearly compromised, and the whole process of having the committee to identify the ablest, bold, and independent persons got. And one point which is not here, Lordship, which I have somehow got omitted in this written arguments, is that it is important, Lordship, that this is not a committee. This is not there in my submissions, but I'll just add it here just to clarify. Lordship, it is not, such committee is not a committee, Lordship, because the other two members of the committee are nominated by the minister himself. So it is a one-man show, Lordship. That is a very important point. It is committee only in name. Under the rules of business, all orders in matters which don't require to be referred to the Prime Minister or cabinet subcommittee, the minister is the final authority. So in this case also, the minister can nominate the other two members of his choice. And that is what has been done in this case. The other two members were nominated by the minister. So virtually, it is a one-man committee, not the search committee. In all other cases, Lordship, in all other for all other offices, the search committee generally consists of the cabinet secretary, the secretary department of personnel who handles the senior officers matters, and the secretary of the department concerned. So here also we have proposed that the search committee should be the cabinet secretary, secretary of the department of legislative department, which is the concerned department, and the other member, the secretary of the department of personnel, because he would know the biodata of the eligible officers.
Yes.
So that should be the. So it is not committee at all. It is just one-man show, Lordship. That point somehow got omitted here, but it is there in the writ petition, Lordship.
Very well.
Thanks, Lordship. Then, Lordship, I'll now come to section 7.1 relating to the section 7.1. This is this was regarding section 6 relating to subcommittee. Then I come to section 7.1 relating to the selection committee, Lordship, as to why it cannot be sustained. Likewise, the composition of selection committee in section 7.1 is also violative of Article 14 for the following reasons detailed in para 59 of the
Right.
petition. These reasons I have detailed in para 59 at page 37 of my writ petition. And now I'll just briefly summarize these reasons. The first is mere inclusion of the leader of opposition is meaningless, as his opinion can be ignored and overruled by the Prime Minister and the Minister as has been done in this case, defeating the whole purpose of having a selection committee. So here again, it's a one-man show. It's not, it's committee in name only. The decision maker is the Prime Minister. That is the first thing. Then the second point, Lordship, is the present composition by a 9 judges bench in the second judge's case and reiterated by 9 judges and another 9 judges bench in the special reference, wherein it was held, Lordship, and I have quoted from that judgment, wherein both the 9 judges benches, Lordship, they said this, and I quote, attention has to be focused on the purpose. What is the purpose of the committee? The purpose of the committee is to get a person who is acceptable to all political parties or to most political parties, not only to the ruling party, Lordship. Attention has to be focused on purpose. That purpose is missing here, Lordship. It doesn't pay attention to the purpose of the committee, the selection committee which has been provided in the Act. Then to enable better appreciation of significance of the role of each participant. Each participant of the selection committee has a role, and that role has to be appreciated. The present composition does not appreciate that role. I mean, doesn't leave any scope for appreciating the opinion of the leader of opposition, Lordship, because the other two can combine and take a decision and ignore his opinion. So that the role of the third person is zero in this case, Lordship.
Yes.
With the consciousness that each of them has some inherent limitation. That limitation is already inherent in PM and the minister being on the one side. So naturally, that limitation is that they would like to have a man of their choice rather than listen to the third member of the committee. So all these, and it is only collectively that they constitute the selector. That is the 9 judges bench, Lordship. That they collectively constitute the selector. So to say that the 2 members of the selection committee are good enough, they can take whatever decision they want. This sort of decision making is totally against the 9 judges, 2 judgments of the 9 judges bench's, Lordship. That is our second point, Lordship. Then, Lordship, the third point is that it does not remove the grave lacuna in the procedure for appointment of CEC and ECs, for the removal of which the Constitution bench had intervened, defeating the whole purpose of the well-considered decision. That is another point, Lordship.
Right.
In this respect, Lordship, paras 160.
We will look into it. Come to your point 4.
They have already been brought to your Lordship's kind notice. In point 3 is, Lordship, this is in para 62, which I just mentioned. Point 4, yes, Lordship. Point 4 is, as brought out in paras, 1 minute, Lordship, I have difficulty in reading. As brought out in paras 84 at page, para 84 at page 57 of the writ petition, the selection committee, as it is constituted, has an inherent incapacity to select the best person through an objective assessment. The composition of the selection committee has an inherent incapacity to select the best person on an objective basis, Lordship, for the simple reason that the other 2 members can overrule the third person. So there is no objectivity in the selection. So for these 4 reasons, Lordship, our submission is
You
that
have
section
referred to
7.1
Justice Nagaratna.
cannot be
Is there a
sustained.
judgment? Please see written submissions, paragraph, page 3, foot.
Yes, Lordship. Page 3. Yes, Lordship. I'm on page 3 only, Lordship. I have not mentioned the judgment, Lordship, but this point was made in one of the articles. Para page 57, 84. this supports our submission, Lordship, that the only way to save this impugned provision is
Very well.
to
very
read
well.
it down
Come to
with
your
this
next point.
proviso.
Section 8, why is section
Ji, Lord.
8 ultra-virus?
Section 7.2 also, Lordship, for the reasons stated above, the totally unnecessary and undesirable provision in
Very
section
well.
7.2 of the Act also
Very good.
needs to be struck down.
Come to 8.
Then, sorry, sir. Yes, Lordship. Then the impugned provisions, one more submission, Lordship, that the impugned provisions in section 6 and 7 of the 2023 Act are also against the object and purpose of Article 324(2) of the Constitution as interpreted in the observations in paras 164, 165 and 186 of the judgment of the Constitution Bench in writ petition number 104, 2015, Mr. Panmal's case, reproduced in para 62 of the writ petition, Lordship. Then, Lordship, in view of the position stated above, our submission is that section 6 and 7 of the Act are liable to be struck down in terms of the law laid down by the Honorable Court in Akhil Bharatiya Upbhokta Congress. I've given the citation, para 50, and in Maneka Gandhi versus Union of India, the citation I have mentioned in the written submissions also. Plus, I have also added some other rulings of the Honorable Court from the SCR, Lordship. So for the law laid down in these cases, these provisions are violative of Article 14 and they cannot be sustained, Lordship. Then, Lordship, page 46.
It's not here. The reading is not here.
Lordship,
Any
my
further
next point
submissions?
is that, Lordship, yes. The next point is that the provision in section 8 of the Act without any norm or guidelines in this regard is also not in accordance with the observations in 2023 4 SCR 284 para 6.5 cited in para 64 of the writ petition. Hence, this provision needs to be supplemented as per prayer 642 in the petition. Lordship, in para 64 of the writ petition at page 46, Lordship, I have said that that the provision in section 8 of the writ petition is not in accordance with the following observation of the case just I cited in para 6.5 of that judgment, and I quote, Lordship, even otherwise also we are of the opinion that Rule 6.9 lacks transparency and it confirms uncontrolled discretion and excessive power to the selection committee. Under Rule 6.9, the selection committee is empowered with the uncontrolled discretionary power to determine the procedure for recommending candidates, to recommend candidates to be appointed as president and members of the state and district council commissioners. Now, the same thing is here, Lordship. It only says that the selection committee, what procedure they will follow is not indicated, no guidelines are given. So for the same reason as given in this judgment, Lordship, the section 8 cannot be sustained, Lordship. Then, Lordship, I just
Yes.
There is a similar Constituent Assembly debate for Article 124, raising similar concern that we can't leave it to the executive. And that is the basis of your Lordship judgment in second judge's case and the fourth judge's case, my Lord. I have, my Lord, and I can give your Lordship the page numbers of the debate. Identical concerns are raised that we cannot leave it to the executive. And that's what your Lordship accepted in the second judge's case and the fourth judge's case, my Lord. I want to place that, my Lord. Just by effect.
That is the point.
It 24th May 1949.
Request to you.
I'm
One consolidated paper book of all.
yes, my Lord.
Because we don't know sometimes.
I understand.
Somebody was making an
If
allegation.
that's why your Lordship has
towards-
marked his volume number.
Somebody made an
I
allegation
understand.
towards me that I have not.
Your Lordship has
her
noted the
objection.
volume number. Last volume was marked as number.
So, sir, one consolidated volume of everything
I understand. Very well. I will do that.
at the end of the.
No.
I mean, after the hearing is over.
Very well. At page 231. I'll just-
Actually, you know, Mr. Ansari,
very-
we are witnessing strange things. A party who wins is still aggrieved because his submission has not been recorded.
No,
Yeah, yesterday only.
very well. Lord.
And the answer was your submissions were useless or were of no help and therefore they were not recorded.
But still you won.
And still the judgment is in your favor. So that is why my
Very well. I see. Ma'am.
request to you is,
I-
please give one volume.
Very well. I'll make a compilation, make one volume, my Lord, and give it to you.
Yes, which page?
Which this page 231, my Lord.
231.
231 is what Sibbalal Saxena has said. At present, clause 2 provides that the President shall appoint the Chief Justice of Supreme Court. That means the Prime Minister or the Executive shall appoint. The Chief Justice of the Supreme Court should be completely independent of the Executive, and that's exactly what said for the Chief Election Commissioner. And it is this principle which I want to introduce in this section. At present, I shall be creature merely by Executive. The President shall appoint him on the advice of the Prime Minister. This will take away some of the independence of the Supreme Court. We are hereby providing for the highest tribunal of justice in our country. The tribunal should be above suspicion so that no executive would be able to have any influence upon him. If the Chief Justice of India is appointed by the President or the Prime Minister, then his independence is compromised. But similar, my Lord, views were expressed, my Lord, which I have shown to your Lordship, my Lord, for the Chief Election Commissioner. And this is, my Lord, and I'll just only 258 is Ambedkar, my Lord, what he has said also, similar things. The Professor Ketisa has said page 240. Page 240 top is Professor Ketisa. This follows the general principle I've been trying before this house, that is to keeping the judiciary completely away out of any temptation, contact with the executive or the legislative side. While during his tenure in the ordinary course of judgeship or even retirement, I would suggest there should be constitutional provision against employment, temptation, etc., etc. And finally, my Lord, I just, because at 258, what Dr. Ambedkar has said, my Lord, I'll conclude with that. Yes. With regard to this matter, 258, about third paragraph, my Lord. With regard to this matter, I quite agree that the point raised was the greatest importance. There can be no difference of opinion in the House that our judiciary must be both independent of the executive and must also be competent in itself. And the question is how it is to be, these two objectives could be secured. There are two different ways which this matter can be governed in our countries. In Great Britain, the appointments are made by the Crown without any kind of limitation whatsoever, which means that the executive of the day, there is an opposite system in the United States, for instance, where the officers of the Supreme Court as well as other officers of the state shall be made only with the concurrence of the Senate. It seems that to me, in these circumstances in which we live today, when there is a sense of responsibility has not grown to the same extent as we have found in the United States, it would be dangerous to leave the appointment made by the President without any kind of reservation or limitation, that is to say, merely on the advice of the executive of the day. Similarly, it seems to me concurrence of the legislature is also not suitable. My lord, what I'm trying to say, my lord, that parallel concerns were raised by the members of the Constituent Assembly regarding the judges of the Supreme Court and the Chief Election Commissioner. And that's why your lordship in the second judge's case said that we cannot leave it completely with the executive. And that's why in Barnwal, your lordship, the reasoning behind Barnwal is it cannot be left completely in the hands of the executive.
Well,
And my lord, one more thing, my lord, one more last thing. Your lordship has seen, my lord, the search committee in how it is seen, my lord, just now. Same day, 14th March, everything happened. My lord, I have a suggestion, either way, my lord, whether your lordship upheld it or, my lord, it rejects it. Some procedural safeguard must be there in the manner in which the search committee or the selection committee must function. And which is, my lord, I have just, that's so that this can also be responded, my lord, by the government. Now, lordship has seen search committee. There is no guideline as to who will make the search committee. In the Lokpal Act, there is a provision that the search committee will be constituted by the selection committee. Now, since in Lokpal, that provision is challenged. In my petition, it was not challenged, so I didn't argue. Search committee under Section 6 shall be constituted by the selection committee at least 2 months prior to the consideration of filling of any vacancy. The search committee shall prepare the panel of 5 persons for consideration of each vacancy at least 1 month before the vacancy. Every member of the selection committee shall be entitled to make inquiries from its own source or from any other government agency about the candidates recommended by the search committee. Every government agency shall be bound to give response and furnish information sought by any member of the selection committee. The members of the selection committee shall be given at least 2 weeks advance notice before the date of the meeting for selection of the Chief Election Commissioner, so that the process which happened, my lord, in the case of last appointment, it does not happen. And there is no, my lord, guidelines. There is no question of, my lord, anything contrary to the statute. It only says this procedure would be decided by the selection committee. There is no decided procedure. That's why on 14th March, everything happened. And there is no requirement that when did the search committee, how do they constitute and when do they recommend? My lord, purpose is the meaningful discussion. Now, even if the Chief Justice of India is there, my lord, he is given on the same day the names. My lord, there is no meaningful and effective discussion. And these, my lord, suggestions in my speculative submission will take care of it in that eventuality, my lord.
well,
I'm extremely grateful to your lordship.
yes.
Lordship. I have my written note ready, but before I take your lordships in some length into that, I keep wondering, when you open up an invitation to the court, that here we have a set of precedents which say how Parliament will probably focus attention to our observations, concerns, stated by way of norms, principles. And if Parliament does not, as the court desired to happen, did not focus the attention on that, somebody will come back to the court and say, Parliament, invoking administrative law principles, did not apply its mind, disregarded your judgment, and therefore they were bound to act entirely in terms of the judgment of the court. Anything with the Parliament to choose otherwise would be not in consonance of what principle, I'm not able to understand. What's the principle which somebody can place before the court to say the Parliament's authority to not to abide by or not to go by or to deviate from a principle or a norm set down by this court will be tested on what principle? Your lordship being asked today to enter into that domain. I am not talking about whether 142 is a reservoir for doing complete justice. When court lays down certain principles or norms, in certain circumstances, one of my submissions going to be that in the context of illegality of particular legislation, testing the legality of the legislation or state action, the court enters into a declaration of law exercise. Where a declaration of law happens, testing the legality of a legislation or any state action, the court they say this law is bad for the following reasons. The court will not go thereafter to say what would the law look like or what should the law look like. But in a case where there is a need for the court entering into doing complete justice, the court may then say, please consider the following ways of doing complete justice. So we have had all those varied circumstances 142 has been invoked. That will stand entirely different footing. Therefore, my first proposition is Anup Baranwal is not a case where a legislation was sought to be put to test. There is no declaration of law in that strictest sense for the purpose of Article 141 of the Constitution. It's a case where people came to the court saying, for so many years, for 75 years, Parliament has not enacted a law. And there are several reports and commissions which apply their mind in the regard to what could possibly a law look like. And therefore, there is a vacuum. We in the context of the vacuum, the court looks into 3 or 4 propositions, which would probably appeal to the court. 1, 2, 3, 4, 5. The court picks up one proposition. I'm not entering the question whether the Anup Baranwal 5 judges were in wisdom in picking up one particular proposition. I'm not entering to at all. I'm not asking lordships to sit in judgment or an explanation about what Anup Baranwal said is correct or not. But therefore, if it is not a case of, not a declaration of law, in the strictest sense of the term, then today, your lords are being asked to act as an executing court of what Anup Baranwal has said. In other words, Anup Baranwal number 1, if the lordships thought, there will be Anup Baranwal number 2. The court thought, I will beget another Anup Baranwal, where this court will sit in execution of a previous order. We are entering into a very different, a thick boy doing, he is now getting into it. It's a very important question for the court. All of us are certainly concerned about free and fair election. Nobody has disagreement about that.
Mr. Attorney, let us be very clear on one point.
Yes.
We feel that Anup Baranwal
Yes.
is a classic case of judicial restraint and statesmanship. Anup Baranwal consciously insulated itself from laying down a law under 141. If it had done so, it would have been accused of judicial legislation.
It had no occasion to do so.
It could have, it did not. It only laid down broad norms which are to be kept in mind. Now, why was it required to do so? Baranwal plays the history, 70 years, no law. Then, by its order, constituted an interim committee, which was to function till such time law is laid down by the Parliament under 324.
Can I halt here for a minute, Lord's permission? If during that interim period, if the executive had not acted in terms of the interim arrangement, the position would have been different, right? The question would be then, till what time will that interim arrangement last? If it would be a purely interim arrangement, because if there was, what you'll also make a note about this point, that when Anup Baranwal initially came in 2015, there was a vacant post of an election commissioner. It was in that context they wanted the court to engage in and find out which is the best way of going about appointment of election commissioner. By the time the judgment came, the position is different. Therefore, if it's an interim arrangement, because
what we want from you is this.
Yes.
You know, arguments have been advanced from the side of the petitioners,
Sorry.
challenging the law on 2 basic grounds. One seems to be that Anup Baranwal has been violated. We are not on that.
I'm also not on that.
We are not on that.
Yes.
You will have to address us on the point that the virus is being tested on the ground of Article 14, read with 324. Free and fair elections have been held to be basic structure that can be accomplished by an independent ECI.
Yes.
Now, ECI can only be independent if it has independent commissioners. Now we come to the basic fact, whether the commissioners, in the manner they are sought to be appointed under the law, whether it is contrary to 14 and 324.
So we are in a critical situation. If this law is applied the way it has been applied, they will, for all practical purposes, the only outcome will be they will lack independence.
Because
It's a-
the
it's a-
judgments of this court from 1950 are eloquent on this proposition that the executive cannot call the
No,
shot
I'm-
so
I'm-
far
I'm-
as elections are concerned. It's not
certainly-
only Anup Banwal,
certainly-
there are different other,
that
right?
today,
So therefore, you will have to address us from that angle.
I will do that. I'll do that. I'm not going to fighting shy of that. But something basic, some basic concern is what is bothering us. If therefore, whether we'll test the law without reference to Anup Banwal, either we test it with the reference to Anup Banwal at all. In which case, we close our mind to the history of entire history, what is stated in Anup Banwal, and see as if the parliament has enacted a law for the first time today. Then it will be an entirely different way of testing this legislation. But Anup Banwal casts its shadow, whether you like it or not, in the reasoning which would probably get into the adjudications matter. It just can't be kept aside.
Cannot be.
Therefore, I understand if that judgment, good or bad, right or wrong, if it is kept as a platform for a further reasoning to persuade the court to say this act is bad for the following reason, I would probably say unless it is tested on the actual application of the law, the chief election commissioner and the election commission appointed have actually displayed a lack of independence in the actual functioning. The actual functioning lack of independence is different from saying, if you follow this law, perhaps and perhaps, you will have election commissioners who will definitely lack independence. It's a huge hypothetical, argument being placed before the court. I'll try to make good this argument, but my concern is that if we have to take this court into a, as I said, the Anup Banwal number 2, for the sake of argument, I'm using the expression. The court is being asked to say that if there are certain precedent that tells us how legislature should have probably, apply their mind to it, legislature has not done so. Therefore, we will examine the question as to what probably and in what best manner the legislature would have applied its mind. So this court, in another way of speaking, is being asked to enter into the legislative arena. In a way, you probably cannot. It may.
Legislative wisdom.
No, I'm talking
Please
about the
do not take
legislative
it that
arena.
We are questioning legislative wisdom.
Uh,
It's only that
yes.
when the Supreme Court speaks, the legislature cannot say that.
If today, for instance, there's no Anup Banwal at all, Parliament chose to enact this law, and it's ought to be put to test again for the first time before the court. The court will look at it from certain facts we plead before the court, and facts will probably carry weight with the court. So to say that merely because for a long period of time, and for good reason, I'm not saying discounting them, from the Constituent Assembly debates onwards, the independence of the Election Commission, there can be no other point of view on that. Nobody can say no to that proposition. But merely because the executive cannot have the exclusive stay, then how do you really test? The test of the pudding, you must eat the pudding and find out whether the pudding is bad or not. Therefore, your lordship today being asked to enter into a pure legislative arena. And why is it so? On the basis of what certain set of precedents have said the basis. That's going to be a very problematic area. You'll also, for good reason, say election commission, we need free and fair elections.
We'll test it.
Yes.
We'll resume after
I
recess.
thought I'll open up some concerns here. It's not merely a mere response to this case. It's something which is broader, very, very broad.
The question of constitutional credibility also, sir. We'll come back at 2.
The district judge says, because they asked the officer, the PP, my lord, you've not arrested her. They said, actually, we didn't find any money trail. There is no connect in that sense. He says, surrender within 7 days. The High Court, my lord, replicates the same error, and your lordships have said, my lord, apart from anything else, that if you're rejecting anticipatory bail, you can't direct arrest. That's the job of the police.
You will be happy if we delete
No,
that
no.
part.
And not only that, I'm saying
The-
this is something that the courts below are not following at all. Now, please see the police's stand. Please see paragraph 9, my lord. Would my lord just oblige me?
It's just a change of a baby, right?
Yes, my lord, because someone said,
Now you are a nursing officer.
I am a nursing officer.
They have some call detailed records, they have some CCTV footage.
No,
Right?
not with me.
Yes,
Can-
FSL also is there.
if
Huh?
you-
FSL
yes.
The
Milord,
exchange
I-
happened in the maternity
Can
center.
I just complete because my lord is putting a
No,
question.
I want to correct myself. It's 60 people per day. It's very small babies.
Now, please,
So I want to correct because I,
no, my lord,
it's
it
the
is
wrong
the
figure.
problem. My lord Justice Sharma is right. It is a problem. In fact, my lord,
problem.
now please see paragraph 9. My lord, please see page 34.
How
My
to
lord,
find out if somebody is innocent
my lord, please.
at this stage.
No, I'll tell my lords why in this case, my lord. Please see page 34. My lords will
Page?
apply. 34, my lord.
34.
This is the district court's judgment. Paragraph 9.
This country.
Paragraph 9, my lord. Now, my lord, please see paragraph. This is what is recorded. The district judge says, my lord Justice Dutta and Justice Sharma, please oblige me by turning to
Yes,
page 34.
para 9 page
That if,
34.
Yes, my lord,
I'm
this
not
is part
saying
of the trial court
discounting
judgment.
them. From
In
the
this case, as
Constitutional
noted
Assembly
above,
debate
the
on
applicant, that is
the
me, has been
independence
sent
of the
for trial
Election
for grave
Commission,
offences,
there could be
etc.
no
for
other
trafficking.
point of view on that.
Applicant is working as a
Nobody can
nurse
say no to that
at a
proposition.
public health center,
But
and as
merely
per
because the
allegations,
executive cannot
the
do this
accused
to this
Devaki
day,
approached her
then
saying that
how
she
do you
wanted
really
to give
test?
her, this is the,
They
my lord, the
test
so-called
the-
abductor,
the
wanted to
pudding.
give
You will
her,
eat the pudding and
give away
find out
her
whether
child.
the pudding
The
is bad or not.
prosecution appears to
Therefore, your lordship
concede
already
that
asked to enter
Shirley,
into
that is the
a
petitioner before my
pure
lord,
legislative-
Sheila, my
legislative
maid,
arena.
Banita and Dheer Singh,
And
this is
why
the
is it
couple
so? On the basis
which wanted
of
the child, may
what
not have had
certain set of
knowledge that
precedents have said
Devaki
that
was
to the
not
basis.
the mother of the
That's
child, the
going to be
birthing
very
mother. my lord.
problematic area.
Bona
Your lordship,
fidely
for
believe
good reason,
my
say
maid
election
said their
commission says
brother-in-law
we
and
need
sister
free and
wanted
fair
a
election.
child.
We'll test
I
it.
just put
Yeah.
them in touch.
This is after
Now, my lord,
I'll
please
open
see
up some concerns here. It's not really a
11.
mere response to this case. It's something which is broader, very, very broad.
The question of
Now, of course,
constitutional
then 11 and
credibility
12.
also.
And if your lordship would see, then in paragraph 15, my lord, the trial court says surrender
We'll come back at 2.
within 7 days. The High Court, my lord, as I just informed my lords, says the same thing. But see the reply of the prosecution. Why did they not arrest me, my lord, is very crucial. Place 27, my lord. I have no... Yeah, my lord, charge sheet has been filed. So at this stage, in fact, my lord, I am told, my lord, when it first came up before the High Court, my lord, though not relevant, would my lord just first turn to page 27 is the reply to my application and 28 paragraph 5, my lord. Paragraph 5, my lord, Justice Sharma.
Paragraph 9,
5, my lord.
5.
Page 28. This is the reply of the prosecution, my lord. Accused,
So where is the apprehension now?
my lord, after the charge sheet, because...
After if they have not arrested you prior to filing of charge sheet,
Yes, my lord.
they
Now,
are seeking anticipatory, there has to be an apprehension
no,
of
the apprehension is because
filing an anticipatory bill.
my lord, because the trial court said that. In fact, the trial court confused.
What did the trial court say?
My lord, I just showed my lord. In fact, my lord, the trial court said within 7 days.
Well, the
Because-
anticipatory bail, where was the apprehension?
My lord, my lord,
If they say
I'll tell
this
my
is-
lord,
this
my lord,
is submitted
a lot of
in
things.
April 26, right?
What happens when you appear trial court? Trial court says, oh, you've arrested XY. Only Banita has got bail. That's the adoptive mother, my lord. She got bail because she has 4 girls, my lord. Now, they said, what did you do with your...
Why do you want to take him,
But it's charge
take
sheet
her
is
into
filed.
custody now?
There's no apprehension of arrest here.
So we'll record that,
No, my lords,
dispose it off.
no, my lords, the need, it might in future if some need arises, we cannot say. But right now there's
Now
no,
what you want to arrest her?
my lords, we do not want to arrest her. Right,
That's good enough. Stop there only. Write it.
my lords, the charge sheet has been filed. My lords may understand. My lords may appreciate. Only thing right now till
The entire investigation, she was not arrested.
she was not arrested, my lords.
You don't want to arrest her.
No, my lords, all I am submitting at this stage is that, my lords, presently if she's cooperating, there's no apprehension.
Required for
But-
further investigation, she shall join. Allowed.
Deeply obliged, my lord. My lord, but this I don't know. I'm just replicating this law of directing arrest, my lord. All of them are saying this.
All of them are?
Not when an anticipatory bail is rejected. Your lordship have said the courts have no jurisdiction to say arrest.
You reject it.
No, I'm just saying your lordship needs to re-emphasize this. This is happening.
Justice Padiwala has said just a week back.
Your lordship knows, but when this is still happening at the High Court level, I don't know. Whatever matter, my lord. Your lordship may do it in some other matter, but this is happening. I could have understood the district court doing it, but the High Court doing it and not reading your lordship's judgment is.
What do you mean to say?
But High Court must have dealt with this matter before Justice Padiwala's judgment came.
I leave it at that, my lords, before that.
One of the finest judges has in that order.
You're right.
A mother. A
Well,
mother.
my lord, I know.
Yes.
Very well.
Wait, please, my lords. My lords, here the direction was to consider his appointment if there is no other legal impediment. We have done that. The rules require that he should have a
So
type
what
of-
happened on 17th April? You
Yes.
sought for an adjournment.
Yes, my lords. In fact, I filed an additional documents.
Acha.
I
The
put all
court
the
has
other
kept it
orders.
When?
My lords, this was filed yesterday. There are 3 additional documents.
15th.
So the matter is now listed tomorrow. So my lords, first it was listed on 1st May. After that, we filed an additional on which date we were told to explain why the 2015 rules will apply and not the 1974 rules. This is all contempt jurisdiction, my lords. That is the first. We filed that affidavit. Then the matter gets listed on 17th April, my lords, page 8 of my additional documents. There, in this case, on the issue of applicability of the 1974 rules, we have to file another affidavit.
So where is the order of 17th April is quoted?
Yes, my lords, page 8.
Page
8 of my additional documents, my lords.
Page 8. Now, did you personally appear?
No, my lords, after that, we did not personally appear. We filed the
You did
affidavit.
not pay the cost also?
My lords, I think the cost has been paid. I am not,
Cost has been paid.
my lords, I will have
So
to
if
check.
the cost is paid, you're exempted from personal appearance?
I will have to, I will confirm that, my lords. I will take instructions on that. The issue is not this, my lords. The High Court can decide the matter.
The issue.
They may just require us, because they are constantly seeking affidavit after affidavit going into the merits of the issue. The merits of which rule is applicable. The order of 3/12/24 just said, consider the appointment. We have done that. We have filed 3 affidavits stating that. Yet, contempt proceedings continue. That is what we are troubled by, my lords. My lords, in fact, if my lords see page 60, that is the operative order. Para 14. Are my lords at page 60, para 14?
No, we thought that you were